Hi, I'm Ken Lammers. Welcome to this week's Cltv. And this week it's time for the Fave 5.
The number you have reached, 911, has been changed to a non-published number.
Hi there, Ken Lammers again. Welcome back to Cltv, and today we're going to discuss my favorite 5 posts from last week in the criminal blogosphere. And we're going to start out with objection. And objection, my fellow prosecutor, I think maybe the only one, no, Tom's posting again, one of the 3 that are posting primarily on legal issues, he's blogging about his first trial in what we would call circuit court here in Virginia. He calls Superior Court. I'm not sure which state he's in. Whichever one it is, it's the the Superior Court where felonies are tried. And the reason he's trying this case is because he kind of falls into it. He gets assigned a misdemeanor DUI and figures out that this misdemeanor DUI fits into his state's brand spanking new felony DUI statute, which requires 4 prior DUIs within a 10-year period before you get to the felony conviction. The felony would be the 5th DUI. It's very different than Virginia. In Virginia, it's 2 prior within 10 years, and can get worse depending on how close they are. His gentleman apparently had 4 or 5 within a 6-year period, and so well qualified for the DUI. And of course, there was more to it than that. I mean, he was obnoxious with the officers, fought with them, caused all sorts of problems at the scene. Anyway, he goes to put it together, and one of the more interesting things that he addresses is how do you, basic rules of evidence require that you don't introduce prior bad acts as a because they're prejudicial to the jury, and the jury might use them for to prove somebody guilty. In other words, what I'm saying is he's got to prove the 4 prior convictions of DUI in order to get his 5th conviction of DUI, the felony conviction. How can he do that without introducing the 4 prior DUIs at trial and therefore causing problems? Problems with the evidentiary standards, which say you can't introduce prior bad acts. Well, in Virginia, this is pretty clear. For years, it's been held that the courts have held, or that you just introduce it. It's required by law to introduce it. You just introduce it in the trial. I'm sure I've not seen a defense attorney lately ask for limiting instruction. The defense attorney could probably get a limiting instruction on that if he wants it. However, in this case where we find an objection, his judge decides that they're going to have a bifurcated hearing. The first part is going to be whether or not he's guilty of driving under the influence. The second part is whether or not he's going to be guilty of whether or not he was guilty of these 4 prior convictions. And apparently his state doesn't have jury sentencing, so he doesn't get a trifurcated hearing. And there's been some talk in Virginia about trifurcated hearings taking place in some of the more liberal jurisdictions. I'm not sure that that's legal. As a matter of fact, I'm very skeptical about the legality of that. I don't see where that is allowed under the laws and rules in which we conduct our courts in Virginia. And if that's not allowed as a specific ability of the court, I don't see how it could be done. But there are rumors out there that certain courts are doing it, and until there comes a reason for it to come before the Court of Appeals or the Supreme Court of Virginia, well then it's not really going to be something we can do anything about here. And anyway, in objection he goes on talks about how, well, obviously he puts up 3 officers to talk about the guy, the intoxication of this guy. I'm not sure how many officers it takes in his state to arrest a DUI. No, there are reasons for more than 1 officer. But it's an interesting read. I suggest it to you all. Next, we're coming to defending people, and Mark has. I got to compliment Mark. I really like the redesign on the blog. He's done a really good job of redesigning the blog. One teeny little exception. For some reason, my link has disappeared, but that's fine. I mean, I'm just kind of joking there. But I really do like the new layout. Anyway, he goes into it's kind of a short blog post, but it caught my interest. He starts talking about how, kids really shouldn't be using drugs, duh, and how drugs are not, use of drugs is not a victimless crime. But then he goes on further to talk about how, well, it's not victimless if you use alcohol or tobacco either, and in any case, you can always find someone who's impacted by a crime, by an act, if you choose to illegalize it. So I think it's fairly true. I'm not sure that it extends as far for things like cocaine, heroin, PCP, as that argument might make a little bit more sense for things like, say, marijuana. Although, even in his own example, marijuana affects people in certain ways that we really would prefer they were not affected, and I'm not going to get into the whole legalization argument. It's a good brief thought, and what kind of caught my eye was the victimless crime thing. There is no such thing as victimless. No act doesn't impact another person. So the third post I have today is from In the Moment, and we've not brought In the Moment on in the Fave 5 so far, but it has an interesting post. It's he has a client who is cooperating with the police or some such thing, and the police want to do a polygraph exam on this gentleman, and he calls his defense attorney, and the defense attorney, who's David Terrell, who's the author of this blog, says, no, don't take it, polygraph. Well, of course, the police arrest him immediately after the polygraph. Next thing, they're in court for a bond hearing, and the judge sets a bond that's higher than, that's high, and then David Terrell's got the defendant's mom yelling at him for, look what happened, he followed your advice, he's locked up in jail now, and he thinks that his advice, and there may be, I think, some objective reasons to believe this, that his advice will probably mean that the guy spends a few months in jail waiting for his trial, but won't spend a few years in jail, which, if he continued to cooperate, it might very well have. So we go on to my fourth choice this week. And for the fourth choice, I'm going to actually move outside of the practical blogosphere to a professor blog. It's Crimprof blog. And Crimprof blog is discussing Kennedy against Louisiana, and how, in this case, the government has flipped the arguments that the anti-death penalty activists have been using for, their last several years, in which they have used social arguments and trends to stop the use of death penalties, and the death penalty in certain ways. And in this case, the state flips it and says, look, death penalty for child rapists. It has been a growing trend. There's only 6 states that say that child rapists should be subject to the death penalty, but it's a growing trend. It's happened over the last decade or so, and therefore it is something that is a growing part of the consciousness of the society, something along those lines. And therefore it, since capitalization is slowly gaining in this area rather than, being drawn away like it was in underage capital offenses, that because it is gaining in this area, it shows that, death penalty for child rapists should be accepted as constitutional. And as far as it goes, I agree. It's an interesting flip on the argument. It's not as strong as some of the other cases that he refers to, because it is only 6 states over a period of about 10, 12 years. It'd be stronger if it was like 20 states over that same period of time. Don't know. I still think it loses because of, it's 6, and even when we had the death penalty for minors and death penalty for mentally handicapped, there were a lot more states than 6 that allowed it, and the Supreme Court said no. Now, of course, Justice O'Connor's gone now, so I suspect that dynamic may be gone now, that the death penalty may not be as hard to put forward as it was once upon a time. And in the end, personally, I disapprove of this anyway, using one side or the other. If you're talking about social science evidence and presenting it to a court, saying this is what the social science says, you're asking the court to perform a legislative function. You just are. So, especially in cases like this where it's not a clear-cut call. If it was all 50 states, or say X, but the District of Columbia says Y, then maybe, well, that's not even social trend evidence, though. You could, I guess, continue to use. One way or another, it all smells like legislation. And finally, we come to Simple Justice, and Scott at Simple Justice has just a blog post that tickled me and reminded me of one of my pet peeves. He talks about the problems with phone receptionists at various law firms, where you call in and you get the phone receptionist, and the phone receptionist, is taciturn, won't say anything to you, won't tell you anything, and you're like, is John Smith there? No, he's not here right now. And then you have to ask him, well, can I leave a message? And he talks about how he can prompt them to do that. I've actually had receptionists say no before, but and then after he prompts them and gets them to leave the message and says thank you, they say no problem, which drives him absolutely nuts, because of course it's not a problem, it's your job. The more appropriate answer being, you're welcome, sir. Something along those lines, polite. And personally, my gripe for phone receptionists is this. You call it, you get law office, and that's it. They'll answer the phone, law office, and that drives me nuts. Now, I know where it comes from, or at least I thought I knew where it came from when I was in Richmond, and there were a whole bunch of people doing office sharing. You had one receptionist who had like 4 or 5 lawyers in this little office that they were sharing, so they could share rent and utilities and stuff. But none of them were actually partnered up with each other. So they'd say law office so that you wouldn't get the idea that it was, that they were tied together somehow. And it kind of made sense, and it could be softened a little bit with, thank you for calling law offices, how can I help you? Something along those lines. Not that a lot of them did it. A whole lot of them just answered law office. But the thing is, I've moved out here. I've not seen, and it doesn't mean that it's not happening, but I've not seen a whole bunch of attorneys out here doing office sharing. So when I get the answer law office now, which I still get from solo practitioners, secretaries, I don't know where that comes from. And it is the worst answer I've ever heard for a phone. If you've got, this is Mr. Smith's law office, how can I help you? As opposed to law office, pet peeve, just my pet peeve, triggered by Scott's. By the way, Scott puts out a ton of content. It's a great blog, thought-provoking. He doesn't skip, I know I poke at him sometimes and he pokes back, but he doesn't, he's fairly consistent in what he says. All of us have to have some room to be inconsistent as bloggers, but it's a good read. My only gripe is that it doesn't work with Opera, so I have to, instead of using my Opera browser to read Simple Justice, I have to pop up Firefox or goodness help me, Explorer to read his blog. But, you know, what can you say? I'm the one using the weird browser. And anyway, ladies and gentlemen, that's it for this week. I want to wish you all a happy Easter, for those of you to whom it applies. And, you know, Dominus Vobiscum. Y'all have a good week now.